Hello friends, in the series on the income tax cases, today we will discuss a very unique case on section 148. The name of the case is Excel Commodity and Derivative Private Limited versus Union of India and others, and this case has been reported in 455 ITR at page number 341. The matter has been decided by Calcutta High Court and the date of the judgment is 29th August 2022. In this case, a notice under section 148A clause B issued to the assessee on the allegation that the assessee is dealing in fictitious derivative trading. When assessee received this notice, the assessee submitted a detailed reply to the learned assessing officer that the assessee is not dealing in the fictitious derivative trading, and when the reply of the assessee was received by the learned assessing officer, the assessing officer did not issue the order under section 148A clause D on this matter. But when issuing the order under section 148A clause D, the assessing officer raised another point that the assessee has taken some accommodation entries with some company and issued the order under section 148A clause D by incorporating the new allegation on the assessee. When assessee received this order, the assessee moved to the writ court and the court quashed the order under section 148A clause D and remanded back the matter. The point of the assessee was that in this case, the matter not only should be quashed, but it should not be remanded back to the assessing officer. Because in this case, the information on the basis of which the assessing officer was relying was not correct, and the main basis for issuing the notice under section 148A clause B was dropped. So the order under section 148A clause D cannot be made on some other point. The assessee also said that the word information written in the explanation to section 148 should not be interpreted so lightly that it gives tremendous power to the assessing officer to issue notice in any case. The assessee also brought attention of the court towards the circular of the department, which admits that all the information which has been uploaded on the portal for issuing the notices under section 148 is not correct, and gave instruction to the department officers to verify this information before issuing the notices under section 148A clause B and further proceedings. So if this instruction and the definition of the information is considered, then the point of the assessee was that in this case not only the matter should be quashed, but it should not be remanded back to the assessing officer. So the assessee filed the appeal against the writ order of the Calcutta High Court. When this matter went to the appeal court, the court held that in this case, the order under section 148A clause D is not based on the ground on which the notice under section 148A clause B was issued. So in this case, not only the matter should be quashed, but it should not be remanded back, and it is void ab initio. The court held that in this case, the order under section 148 is unsustainable and illegal, and in this case, there is no necessity for remanding back this matter because whatever the information was available with the assessing officer was not correct. At the end of this video, once again I am repeating the name of the case. The name of the case is Excel Commodity and Derivative Private Limited. This case has been reported in 455 ITR at page number 341. The matter has been decided by Calcutta High Court and the date of the judgment is 29th August 2022. Friends, before relying on these judgments, it is my request to all my listeners that please go through the whole judgment so that you can know the exact facts of the case, so that you can apply the judgment in your case more appropriately. Thank you, friends.